everyone.
Hello. Wow. Hello.
Well, it's a good thing that this works because I would have no idea how to fix it. So thanks everyone for coming by. I am Justin Voeks. I am a shareholder in Reinhart's corporate group, where I focus, most of my practice on mergers and acquisitions of one kind or another. And I'm here with my colleague Melissa, and we're going to talk about emerging legal trends. And I'll let Melissa introduce herself.
My name is Melissa Zabkowicz. I've been at Reinhart since my career started about 6 years ago. I'm a senior associate, and I've been doing M&A primarily ever since I started. So,
I think without any further ado, we're going to talk about the emerging legal trends in M&A that everyone should be thinking about. Just to kind of give you an overview of some of the, the current trends that are, that are on our minds. Probably the big one, which you heard about in the big group sessions, just economic uncertainty. There's been inflation, interest rates going up. People, aren't sure will there be a recession, won't there? And all of that has effects on both financing and the M&A markets. So we'll get into that. In terms of other things, we've got emerging diligence issues. When folks are looking to buy a business, they need to conduct due diligence to kind of kick the tires on a number of aspects of the business. And there's always some new hot topics on that front, which we'll talk about. Another trend that we'll get into is continued prevalence of rep and warranty insurance in M&A deals. The rep and warranty insurance product, it's been around for several years now, for most of the time that I've been practicing, and it continues to be very popular and to kind of be growing. It helps you kind of bring an insurer into the deal to take on some of the risk that would otherwise be borne by a buyer or seller. So we'll get into that, and then kind of a final legal trend is heightened scrutiny of non-compete agreements. You may have heard in the news that the FTC is considering a rule that would ban non-competes in a lot of circumstances. Also on the state level, there's lots of sort of trends in which courts or legislatures are taking a more careful look at this. A lot of that has an effect in the employment context, but it can influence M&A transactions as well. So we will get into that. First major topic here, buyer financing is becoming more difficult, and this really kind of ties into the economic uncertainty factors that we've been talking about, and was mentioned in some of the prior discussions. With the economic uncertainty and with interest rates going up, the bank financing landscape is different than it looked a couple years ago. In 2021 things were kind of record-setting deal pace, and financing was relatively easy to get. That has become more difficult. You're not going to necessarily get the same terms that you would a couple of years ago. And banks in particular, especially over the last month with SVB and others, banking is a little bit more difficult too. So what does that mean for deals if you're looking to buy a business or sell it? One thing that you can expect is that a lender is going to dig in more. They're going to need to really scrutinize and kick the tires on the deal to make sure that that the target company is going to perform in a way that that supports the loan. So what does that mean? It can mean heightened diligence. Quality of earnings analysis becomes even more important, and those are all things that you need to be aware of. So then, as we think about how that kind of affects the legal terms of the deal as we document the deal, it's really kind of who bears the risk of what happens if financing isn't available. So we talk about negotiating financing contingencies. So, and I would look at this kind of different ways in two different kinds of deals. In one kind of deal, what we call a simultaneous sign and close, you will sign sort of the definitive purchase agreement for the transaction and close the deal, all at the same time. So in that kind of situation, you don't have to put financing contingencies in your purchase agreement. However, it kind of means that the buyer isn't really, contractually obligated to do the deal until you're actually ready to sign and close. So, so if their financing, isn't there, then they can just kind of walk away and likely won't have any consequences at all. Another kind of deal is what we would call like a staggered sign and close, where you would sign the purchase agreement first and then close some period later. It may be a few weeks, it may be a few months. A lot of times you'll see this in deals where there's like a regulatory consent or process that you need to get through before you close. So then you sign an agreement first and then potentially announce it at that point. And that's when you go to your regulator, and once you have approval, that's when you close. So it could be a regulatory consent, could be other factors as well. Whether it's a third-party consent, sometimes even just to line up the debt financing, you would sign first and close later. So if you're documenting your deal that way, then negotiating the financing contingencies becomes very important. As a seller, you don't want a buyer to be able to say, well, if my financing doesn't show up, I can just walk away, no questions asked. So you want to have covenants in your purchase agreement that require the buyer to to go get their financing, and consequences for the buyer if they're not able to close. Whether that's specific performance provision where you might require a buyer to close, or in some deals that won't be available, but the buyer might be on the hook for some kind of termination fee if their financing doesn't show up and they don't close. So those are all things that we can kind of help you work through as we kind of deal with the financing markets. And I would say, beyond just kind of like what's in the deal documents, another thing, just to really think about in terms of, financing certainty is, when you are a seller and you're evaluating potential buyers, you really want to think about and have them give you assurances about kind of what the state of their financing is. You're going to be in a much better state if you're dealing with a buyer who, has already been in conversations with their lenders. Maybe they've gotten a debt commitment letter from their lenders that shows that the lender's making a commitment to the deal. And those kinds of things. The more kind of certainty that you have, in earlier stages that the buyer has kind of done their homework to sort of bring the debt financing along, that just gives you better assurances that your deal will actually go through. So when we talk about things, more than just price that you need to think about when doing a deal, deal certainty is a real big part of that, and knowing, how a buyer is going to finance their deal and how solid that financing is super important.
All right, diligence. So diligence has obviously always been important to buyers, but it's more important now than ever as banks are tightening up loan covenants. They're being more selective with deals, so it's really important to have everything buttoned up. So as a seller, you should be prepared to produce, and as a buyer, you should be prepared to review a ton of diligence documents. I know we've gotten made fun of a lot today for over-lawyering, but that's a place where it's really, really important for us to request a lot of documents and for buyers to review them and make sure that everything from a legal perspective is on the up and up. And if you're a seller, before you go onto the market, it's really important to get your house in order. So if there's something that's keeping you up at night, it's undoubtedly going to be keeping your buyer up at night as well. And if you don't get your arms around whatever that issue is, whether it's litigation or just maybe some non-compliance issues, the buyer is going to want to figure out a way to shift the risk of that issue post-closing to you. So again, really important to just focus on getting your house in order. There are some more hot topics right now that buyers are focusing on. One of those is PFAS. So it's this chemical that's heat and water resistant. It's used everywhere these days because of those properties. So it's in shampoo, it's in fire extinguisher, liquid, it's in pots and pans, it's really everywhere, and regulatory authorities are saying that it's likely these that they cause harmful effects, and they've proposed some standards to limit the amount of that in your products, in your properties. And because of that, there's likely going to be some regulatory enforcement, so buyers need to focus on whether their sellers are manufacturing products with PFAS, and then how to deal with that. Wage and hour matters, these have always been important, but even more so now. And so this is things like, are you classifying your employees correctly? Should they be independent contractors or should they be employees? Are they exempt or are they non-exempt? If you're getting it wrong, there are some fairly harsh repercussions like overtime pay, back pay, penalties. So it's really important to get all that in order, and a buyer is going to want to make sure of that. Cybersecurity, you all already know, security incidents are on the rise. Any buyer is going to want to make sure that there's security in place on your system so that you're not going to be the victim. Import-export, just with tensions in the world right now, there's government lists that say who you can and who you cannot purchase from. So buyers sometimes dig into where your goods are coming from to make sure you're in compliance with those lists. And then lastly, employee retention tax credits. So this was a COVID era incentive that incentivized employers for keeping employees on the payroll when things were bad. Buyers are scrutinizing whether or not there was justification for taking the credits or taking the amount of credit. So, it'd be good to look into that and just make sure everything's above board. And to the extent you know of issues or there are issues that come up in a deal, often what happens is you'll negotiate what's called a specific indemnity. And this is just a provision that basically shifts the risk from buyer post-closing on that issue to the seller. And that means after closing, you've got money in your pocket as a seller, but you still could have to come out of pocket down the road to help cover those legal costs. So again, that's why it's so important to take care of those kind of issues ahead of any kind of closing. And then LOI negotiation. So we've heard a lot about LOIs today already. They're becoming increasingly important because they're just getting more and more detailed than they've ever been. Again, the over-lawyering, but in this context, it is really important because getting those terms right on the front end will save you a whole lot of headache on the back end. Just as an example of this, we recently had a new client come in, had already signed an LOI as the buyer of a business. And in this LOI had agreed to deposit $200,000 of earnest money with the seller. The only ways to back out and get their earnest money back was to not be able to get financing and not get regulatory permission to do so. So we started with this deal. They looked more into the financials. They looked more into just the employees and how this business was operating and decided that this was not the right business to invest in and it would be a bust. But at this point, they don't really have a way out of it, and the sellers got $200,000 of their money. And so we're working right now to try and figure a way out, but if they had come to us beforehand, we would have told them that those kind of clauses aren't standard, and we would have found a way to do without. So as I said, LOIs continue to be more detailed. So typically what you'll see is purchase price, obviously, structure of payment. So Justin will talk a little bit about earnouts, but other options are obviously cash or note. Methodology for determining the working capital adjustment, Justin will talk about. Whether indebtedness and debt-like items are excluded from the sale. Restrictive covenants, most buyers expect them, typically 5 years, so it's important that the seller is aware and on board with that. Employment agreements, like one of our speakers said, management is key, right? So it's really important if there's anyone that's vital to the business that you can't live without, you gotta make sure that you've got them locked up and that the seller is aware that that's what's happening. And then indemnification packages and revenue warranty insurance we'll talk more about later. But all these are important deal terms. They're going to be negotiated down the road, and so we're seeing them negotiated on the front end more before you start spending a lot of money in a deal when there are some deal breakers that haven't been resolved.
All right, so next we have earnouts have risen from the dead. Just to talk about what that means a little bit. So earnouts are kind of a way of allocating the purchase price that's a little bit different. So just to give an example, you may have a deal where you say, the purchase price is $10 million, but we're also going to have like a $2 million earnout. So what that would mean is that the $10 million would get paid when you close, but then the payment of that $2 million earnout, it would depend on whether, it really depends on the performance of the business during some kind of specific period after you close. So the reason why parties like this and why these get used sometimes is that they can help be kind of a bridge between the valuation expectations of the buyer and the value expectations of the seller. So that in that example that I gave, the seller may have started off by saying, we want, $12 million, for the business, just up front, and the buyer may have said 10, and then that $2 million earnout, kind of becomes, a way to bridge that gap. With the logic being that, if the business is doing well enough to hit the target that we've agreed upon, in that case, the buyer is going to be happy with their investment, and then they can pay pay that earnout amount. So all of that sounds great, and one reason why I think we're seeing more examples of it, lately is that with kind of the economic uncertainty that we've been talking about, I think that introduces more opportunities for buyers and sellers to sort of have those valuation gaps that we were talking about. A seller may have heard from his friend who sold his business a couple years ago that he got 10x, and now someone selling today wants that too, but it's not on offer. So there may be that kind of gap in expectations, and the earnout it can be a tool to try to bridge that gap. However, what you need to be aware of if you're thinking about including an earnout in your deal is that these things can be difficult, and it's really important that the parties negotiate them very carefully. And there's several reasons for that. One is that if you're doing an earnout in a deal, each deal is going to kind of have its own sort of very specific set of what goal are you measuring? Is it revenue for the entire business? Is it revenue for the entire product line? Do you want to do kind of an EBITDA-based metric? So there's really as many different types of earnouts as there are deals, and it can be kind of more bespoke than a lot of the other terms in the purchase agreement. And for that reason, it requires it requires more negotiation, both kind of upfront at the letter of intent stage to set people's expectations, but then also in the definitive documents, to make sure that the parties have an agreement on what it is exactly that they're trying to measure, and to make sure that that is defined really carefully, so that when it becomes time to measure the criteria post-closing, that it actually works in the way that both parties were expecting when they signed up for it. And as you kind of get into the weeds on this, there are lots of different sort of what ifs that you think about. For example, you might have a revenue-based earnout, but then a buyer might ask, well, what if I introduce a new product after closing? Should that really count towards the revenue-based earnout if that's something that was really just done by buyer and it had nothing to do with the business at the time that we bought it? So things like that can kind of also become part of the negotiations, and you want to think about it and work with your advisors to really kind of think about what sorts of things could happen in your period post-closing that could cause the earnout to work in a way that's different from how you anticipated when you drew it up. Another reason why these things can be really requiring a careful negotiation is that the conduct of the business during the earnout period becomes really important. The earnout period is typically going to be some period after your deal is closed and the control of the business is transferred over to the buyer. So if the buyer is in control of the business post-closing, as a seller, you might worry that the buyer has an incentive to manage things in a way to cause that metric to maybe not be hit so that they don't have to pay you the earnout. Conversely, a lot of times, a seller will sell their business, but they'll remain, involved with the business. They may remain on the management team. So in that situation, the buyer may worry that the seller is going to kind of use their control over the day-to-day to conduct things in a way that might cause the earnout to be, manipulated in a way that favors the seller. So the way that we'll try to deal with this in the deal documents is, have covenants that kind of set rules for the road, during that post-closing period to kind of say how, whoever's kind of in control of the business, how they're going to, manage things in a way, and really what you're looking for is to, try to get it to be managed the ordinary course, the business, such that the business is being run in a way that's just, best for the business and not being kind of artificially driven one way or another to either hit or not hit an earnout target. And those covenants can be either pretty simple or they can be enormously complicated depending on the parties involved and what their appetite is for negotiation and what their concerns are. Given all that complexity that can come up in the negotiation of these things, it may not be a surprise that these are also a place where we see a lot of, or at least a higher frequency of post-closing disputes. The way things will need to work is that once the earnout period has ended, it'll need to be measured with one party producing the calculation. Usually the other party will have some ability to review and contest it if they don't agree. But because these are money points, and because it's very difficult upfront to anticipate everything that might happen during that earnout period, and because sometimes when people are running the business, there may be disagreements of opinion as to whether someone operated within those covenants that I mentioned or not. There is a greater possibility for post-closing disputes over an earnout than over a lot of other provisions that you'll see in purchase agreements. So, so it's just something to be aware of as you think about it. So, it's a valuable tool, but there are some challenges and complexities that you need to be aware of if you're thinking about including an earnout in your deal. So then next is working capital adjustments, which are another kind of key component that really determines how much a buyer's going to pay and a seller's going to receive at closing. Unlike the earnouts, which some deals have them and some deals don't. With working capital adjustments, I would say that majority of the deals that we see will include these. And the real kind of objective of the working capital adjustment is to make sure that the company has what we call like a normalized level of net working capital at closing, so that when the buyer buys the business, it has kind of the same level of working capital that it historically has. And so when we're talking about working capital, the components will be current assets over current liabilities. So current assets will be things like accounts receivable, inventory, prepaid expenses. Current liabilities will be things like accounts payable, accrued expenses, things like that. So the way that it will work in the M&A negotiation then is you need to set a target for what you expect working capital to be at closing. And then if it turns out that working capital at closing is above that target, then that becomes usually a dollar for dollar increase over purchase price. And on the other side, if working capital falls short, then that would be kind of a dollar for dollar reduction to the purchase price. So in this M&A environment, setting that target becomes kind of a delicate thing. There are lots of different things you need to think about. Kind of the standard sort of plain vanilla way to set that working capital target would be to take kind of a trailing average over a historical period. So a lot of times you'll see like a trailing 12-month average. You'll see what was working capital during each of those 12 months. Take the average, and that can be your target. That's kind of the starting point, but it might not be the right ending point for your deal. And that gets into kind of aspects of the economic environment that we've been talking about. For example, if inflation has kind of cause unusual patterns in your expenses or in your accounts payable. That could cause that trailing average to not be a great guide. Similarly, if you've had issues with suppliers, you maybe had to take on higher expenses during a particular month that drove up your accounts payable. Again, that might cause the average 12 months to not be the right way to think about what the target should be at closing. Another thing that we see a lot is some businesses will be seasonal, where their working capital levels will be higher at certain points during the year and lower at others. So if you're a seller and you have kind of low working capitals during the spring and you're trying to close in April, a 12-month average that has both the low points and the high points factored in, isn't really going to be a good predictor of where you could reasonably end up when you close in the spring. And if you just set them based on the 12-month average, then that's gonna hurt your purchase price to close if you haven't taken that seasonality into account. So those are all things that you just kind of need to think about when setting the target for working capital. Some of those things are perennial issues, but some of them are also kind of more emerging trends. Where the economic environment can really have sort of an impact on what makes sense. And then the last thing that I would say when you're thinking about these net working capital negotiations is that the quality of the company's accounting practices can really be important in how these play out. If your company has kind of accounting practices that that deviate from GAAP or that deviate from kind of industry norms, that can be more difficult to to measure and understand. For example, if you're a company and you don't say you don't book all your inventory, for example, then that becomes kind of a challenge when you can't just look at the balance sheet to say where is that inventory level at, but if it's sort of an off balance sheet because of the way you do your accounting. It can make these discussions kind of more complicated, and it can be harder to, if you're a buyer, you need to be sensitive to, a target company where their balance sheet might not say everything that you need to know. And if you're a seller, the concern can be that you may not get credit for all the value that you're delivering if it's not, sort of properly, accounted for in your financials. So one piece of advice that we would give is if you're thinking about selling a business and you have kind of a bit of a runway where you may not be doing it in the next 12 months, but maybe over some years in the future, it's a good idea to do what you can to kind of bring your accounting practices, kind of up, raise the bar for those, bring them closer, closer to GAAP. Audited financials don't necessarily make sense for every business, but if it's something to think about, because the more that you can kind of get those financials in kind of a GAAP-like state, it makes things makes it easier for buyers to understand, and it's easier to negotiate your deal and easier to sell your business.
All right, so indemnification, this has always been present in deals, but it's changed a bit with the proliferation of rep and warranty insurance in the last couple of years. So the terms of indemnification vary a lot based on whether that RWI is present. So we'll talk about RWI in a second, but first let's talk about deals that don't have, that aren't insured. So indemnification matters because, it really gets to what seller's liability is going to be in the purchase agreement. And it stems from the reps and warranties that the seller is making. So in the body of the purchase agreement, a seller is going to make 15, 20, 30 pages of affirmative statements about their company. So things like the capitalization of my company is X. I haven't breached any contracts, we're not in the middle of any litigation, and on and on and on about every facet of the business. To the extent some of those statements aren't true, the seller will have the chance to disclose against them. So if you are in litigation, then you can go ahead and write that down on the disclosure schedule, and you're safe from liability to buyer for that. But to the extent you make an affirmative statement and you don't disclose against it, the buyer is going to have indemnification rights. So this is basically a right to recoup some of the purchase price from you and get made whole. So in non-insured deals, obligations on the seller with respect to indemnification are customary. It would be very rare to not have some kind of indemnification liability for reps in an uninsured deal. Typically the terms are a lot less seller friendly than they would be if insurance was present. And there's going to be a lot more extensive negotiation on these terms, which is why it's important to do it on the front end at the LOI stage, if at all possible. So currently what we're seeing, market terms for non-insured deals, escrows, so typically at closing, instead of taking 100% of the purchase price and putting it in your pocket, you'll put a small chunk of that in an escrow. And that'll be typically released 12, 15, 18 months after closing. And what it does is serve as a source of recovery for buyer. You know, if you're selling assets, you're gonna have no assets in the business, you're gonna distribute out all the cash, and then the buyer's left with an empty shell to recover from. So that's no good. So you want some money somewhere that's easily recoverable against, and that's what the escrow is. So we're seeing 3 to 10%, 10's a little high, it's a wide range because it's just subject to who has the bargaining power, but I would say typically somewhere in the middle of that is where we fall. General cap, so this is the cap on a seller's total exposure for breaches of most representations and warranties. Obviously a seller wants that as low as possible, buyer wants it as high as possible. What we're seeing is about 8 to 15%, again, often in the middle of that, just depends on who has the leverage. And then baskets, so think of this as a deductible. We're seeing it from 0.5%, even a little bit less than 0.5% to 1%. And this is basically the amount of losses that a buyer needs to incur before it can look at the seller for recovery. So until it hits that deductible, the buyer's out of pocket and it's on them. And it really just prevents a buyer from kind of nickeling and diming the seller. So insured deals. So this is becoming increasingly popular and more accessible to the middle market. When I first started about 6 years ago, I don't think we did deals that were insured under, $70 million. So it was pretty rare to see them in this market. Now, typically 30 million and higher is the range that we're seeing. So it's just become used in a lot more deals. And as representation and warranty insurers are adding more capacity, we might see that number come down as it has been over the last few years. So why get representation and warranty insurance? It really streamlines negotiations. So what this policy does is it basically backstops the seller's statements, those representation and warranties in the purchase agreement. And instead of the seller being buyer's source of recovery for any breaches, the buyer looks to the policy. So it's great for sellers because they don't have to come out of pocket, and it's great for buyers because they know they'll have a source of recovery after closing. So what we're seeing typically right now, and it's great because these insured deals are really standard. Everyone's kind of agreeing to the same kinds of terms. So if you know there's insurance, you know that these terms are pretty much going to be the same across the board. So typically you've got coverage limits of 10% of the enterprise value. Your premium is going to be 3 to 4% of that coverage limit. Your retention, so this is the deductible under the policy, that's going to be 1 to 2% of the enterprise value. And then you've got the buyer taking the first 50% of that deductible, so they incur those losses, they come out of pocket, and then the seller takes the last 50% of those losses, and that amount would be escrowed with a third party, so that in no event is the seller coming out of pocket to make the buyer whole. And then as soon as that escrow is gone, buyer has to look to the insurance policy. So typically 12 months is the survival on those reps, and then the seller is home free on most of the reps and warranties they've made. But there is a cost. These policies are typically no less than $150,000 to $200,000, so it's expensive. Sometimes we see this policy split 50-50. Oftentimes buyers cover it, and that's a good, something you'd want to negotiate on the front end of the deal. And generally, the buyer also procures the policy. It can be either a buy-side policy or a sell-side policy, but typically buyer side, where they're the insured, is what's most popular. So as part of the process, there's going to be a data room that the insurer has access to do their underwriting. Buyer's attorney will write a lengthy diligence memo about their diligence findings, any issues they found. And then at the end of that, you'll have to, both buyer and buyer's counsel will have to participate in a rather painful underwriting call where you get peppered with questions about issues with the business, gaps in the diligence, and after that, the insurer will release a draft policy. And in some cases, if there's issues that they found that hadn't been addressed, then there might be exclusions from the policy. And at that point, that's not covered, and the buyer and sellers have to figure out, who bears that risk. And then there's a new insurance policy that's brand new. We haven't used it yet. It sounds like there's still some issues being worked out, but it's called micro insurance, and it's basically present for deals of $250,000 to $10 million, so smaller end. They're all sell-side policies, so the seller obtains no underwriting, which is fantastic, and they're a heck of a lot cheaper. So again, it doesn't seem like these are widely used at this point because coverage hasn't quite been there. But as we see this product becoming more and more popular, I think it'll be great and a great product for the clients at the lower end of the market to use.
All right. So next on our list, in terms of legal trends, is restrictive covenants, and which are both in the M&A context and the employment context becoming subject to more scrutiny. So what we're talking about here, kind of the classic restrictive covenant is a non-compete, where you might say, that an employee of the business, you're going to sign up to a non-compete. You're going to agree that both while you're employed with us and for some period of time after, you are not going to compete against our business. Similarly, as we've mentioned, restrictive covenants and non-competes are a standard part of M&A transactions. Here, the basic idea is that, hey, the buyer is paying the seller, a significant amount of money for the business. As part of the goodwill of what they're acquiring, they don't want that seller to take that cash and go turn right around and start competing with that buyer. So, so a restrictive covenant, a non-compete, non-solicit, things like that are kind of a standard, part of an M&A deal, with kind of 5 years being a pretty standard length, at least for someone who's the majority seller. So the trend that we're seeing here, though, is that there's increasing scrutiny of these kinds of restrictive covenant provisions. So a lot of that is happening in the employment context, and it's happening on multiple levels. In the state of Wisconsin, there's just kind of a statute that basically says that Wisconsin's not going to enforce a restrictive covenant if it's an unreasonable restraint. So then that kind of comes down to the courts to decide what that means. And what we are seeing is that there have been some examples of Wisconsin courts recently kind of taking a more careful look at restrictive covenants and being more willing to say this restrictive covenant was not reasonable and we're not going to enforce it. And in a recent case called the Godina case, if you're really interested in knowing, a court even took a look at something that on its face wasn't a non-compete provision, but rather just a confidentiality provision, intended to protect the employer's confidential information. And the court, looked at this provision and said, the scope of information that's being covered in this provision, it goes well beyond what's actually confidential or material, and it's not reasonable, and we're not going to enforce this. So that's happening in the employment context in Wisconsin. It's happening in other states too, where either state courts or state legislatures are either saying that applying existing laws to say that employment-based non-competes are not reasonable, or passing more stringent legislation to restrict kind of those employment-based non-competes. Some states, such as California, already kind of prohibit employment-based non-competes, at least in most circumstances. So what does this mean for?
Another minute or two.
Okay, I've got a minute or two, so I will be quick. So what does this mean for deals? If you were looking at a deal and the target has its employees or key employees tied up with restricted covenant agreements, it's worth having your law firm take a look at it. Have a labor employment take a look at it and ask are there any potential enforceability issues here? Another thing to think about is that FTC recently put out this sort of proposed rule that would ban employment non-competes pretty much altogether. There is an exception within that proposed rule for a sale of business, but it only applies for owners of 25% or more. So if that rule ultimately goes through and if it becomes law, which it is not yet, that could restrict what we do for non-competes in the M&A space. Right now I would say that buyers will often look to impose non-competes on sellers if they're getting significant proceeds out of the deal. So if the deal is lucrative enough, you may have someone who has only a 10 or 20% equity interest, but they're getting enough proceeds to support a non-compete. Under this FTC rule, if you're below 25%, then even in the M&A context, that non-compete wouldn't be allowed. With the FTC rule, it's just a proposed rule. It may not go through. Even if it does go through, it may get challenged in court. So, we don't know if it will ever, become enforceable law, but it's something that we're certainly, keeping an eye on, and something that needs to be, thought about when you're doing deals.
And that brings us, there's a couple points on trends around the world. I don't think it matters that much. I don't want to stop you from drinking. So if you have any questions, we'll stick around for a little bit, but really appreciate you coming today. I know there were some really interesting presentations, so it was good to see you all.
Thank you.